Sometimes a party enters a contract to benefit a third party. This is often done as a gift or to pay a debt to the third party. However, circumstances change, and the original contracting parties may want to modify the contract in such a way that the third party no longer benefits. In Olson versus Etheridge, we'll explore whether the third party has vested rights under the contract. Karen Olson and others owned a John Deere dealership in Illinois. Olson sold the dealership to Dean Etheridge and other purchasers through a stock purchase agreement and promissory note. Olson agreed to accept annual installment payments from Etheridge, and Etheridge pledged the stock shares as security for the unpaid balance. 4 years later, in a second agreement, Etheridge sold half of his shares to Engelhaupt, who agreed to assume one half of Etheridge's liability and obligation to pay Olson. The entirety of Etheridge's agreement with Olson was incorporated into the agreement with Engelhaupt. Etheridge later assigned his interest in the agreement with Olson to Princeton Bank, to which Etheridge already owed money. In a third agreement, Etheridge paid Princeton Bank about $83,000 in exchange for Etheridge's releasing his claim against Engelhaupt that was created under the second agreement. After a purchaser defaulted on the installment payments, Olson filed suit against the original purchasers, including Etheridge, as well as Engelhaupt, in the Circuit Court of Bureau County. Although the breach occurred under the first agreement with the original purchasers, Olson claimed that, as a third-party beneficiary under the second agreement, she could sue Engelhaupt. The Circuit Court granted Olson's motion for summary judgment. Engelhaupt appealed to the Illinois Appellate Court, which agreed with the Circuit Court. Engelhaupt appealed to the Illinois Supreme Court.